Hi, this is Kelcy Bremer, and this is my presentation on tort liability. Tort liability is an actionable or civil wrong committed against a person by another that is independent of contract. An intentional tort is when a person intends to affect another person and harm or damage results, even if the harm or damage wasn't the original intent. Intentional torts can include battery, assault, attempted battery, false imprisonment, emotional distress, and torts of property. Negligence occurs when someone is supposed to do something but doesn't, and negligence consists of duty, breach, and causation. Duty is their duty not to expose someone to unreasonable risk or harm. A breach in that duty is when they put somebody in unreasonable risk or harm, and then causation is when their breach in duty causes harm. The first case that I studied was Barrett versus Unified School District number 259. Alex Barrett was a senior football player who had reported to the first day of practice. It was extremely hot. On that day, he began to not feel well during practice and was given extra drink breaks and was allowed to sit out for part of the practice due to not feeling well. At the end of practice, he collapsed on the school's practice field, and he passed away the next day in the hospital. During practice that day, and when he was taking additional breaks, the coach did ask if he was okay and did allow him to take breaks as needed. His mother filed a suit against the district and the head coach claiming negligence and claimed that they were not entitled to immunity because the injury was caused by the coach's negligence and the coach owed a duty to care for his student. KSA 756104 is stating that an employee of the government that acts within the scope of their employment responsibilities are not liable. They're granted immunity for any damages resulting from the use of public property, unless they are guilty of gross negligence that caused the injury. The courts originally determined that this applied in this case, but then the decision was reversed for further proceedings to determine if the defendant's actions were gross negligence resulting in Alex's death. Had this occurred in my school, I do believe that the superintendent would have conducted his own investigation to determine if there was any fault. He would have talked to the coach personally, as well as to the other coaches that were present and other athletes. And ultimately, I think that he would have supported the coach in this issue, although it was tragic. However, based on the details provided in the case study, proactive measures to prevent future incidents would include more training on how to respond and document when students are showing signs of heat illness. This is something that coaches have to go through training for prior to coaching at the district level, but there might be follow-up needed in this situation. And then in this case, genuine care and concern for students' well-being take precedence over the drills and conditioning for a sport. Those are the obvious professional ethics. Coaches need to remember that there are things above what needs to happen in practice. And sometimes as coaches, we can be guilty of seeing the need for practice that day and what needs to be done. But ultimately, our students' safety and health is the first priority. The next case I studied was Hoyam versus Manhattan Beach City School District. Michael Hoyam was 10 years old, and during summer school, he left the school grounds unknowingly to the staff. Once he was off school grounds, he was struck by a motorcycle, and this resulted in serious injury. His mother, upon arriving at the hospital, claimed to have suffered severe emotional and physical distress when she saw him and his injuries. She claimed negligent supervision by the school district, where the cause of it, because by them not knowing that Michael had left the premises, that was the cause of the accident and his injuries, and she sought recovery for medical expenses for Michael, damages for the loss of Michael's comfort in society, and damages for the emotional and physical distress that she experienced just in dealing with his injuries. The school argued that negligent on-campus supervision cannot be the proximate cause for off-campus injury, and that the motorist who hit Michael acts as a superseding cause, which relieves the school of any liability. This case was ultimately dismissed. Once again, I believe that my superintendent would have conducted his own investigation to determine if there was any fault and what would have either determined consequences, if so, or otherwise supported the teacher. We had an issue similar to this in the district recently, where our cross-country team often runs around town, and one of our managers was riding on her bike alongside the team and was struck at a crosswalk. She had minor injuries. The coaches were not there when it happened because we also run through town with students and kind of cross back and forth, checking on groups of runners as they passed different areas. And the superintendent was quick to respond. The coaches and the superintendent were at the hospital with the student and spoke to family immediately. And then there were protective measures put in place for expectations for using streets and crosswalks in the future. For this case in particular, future protective measures could include stricter supervision expectations, particularly during more relaxed summer school sessions, as well as guidelines for accounting for all students in attendance throughout the day, such as regular check-ins. In this case, while the district stated that they could not hold a child against their will if they wanted to leave, lack of knowledge that a student had left speaks to the quality of supervision. In my opinion, this leaves the school's care for students and dependability viewed as less than satisfactory, which would be a concern to parents. The third case was Rollins versus Concordia Parish School Board. Lisa Rollins was a 9-year-old girl who broke her leg when she fell off a merry-go-round during PE class. The teacher in this case had seen that a group of girls were using the merry-go-round unsafely and had told them to slow down and get off. She then walked away to deal with an issue with a group of boys playing basketball elsewhere on the playground. The school board was found negligent in providing adequate supervision based on the fact that the teacher had told the girls to slow down and get off prior to walking away to deal with the other issue. Since she saw a potentially dangerous situation and failed to supervise them until danger had stopped or passed, she failed to prevent a reasonably foreseeable accident. However, the courts also determined that Lisa was contributorily negligent for trying to get off the merry-go-round while it was still moving, which is what ultimately caused her injury. So the amount of the damages she received was reduced by 50%. Another point that was presented in this case was that there was a second teacher that was available to be on duty at the time, but was not. They were taking turns supervising so that one teacher could always have a free planning time. As a classroom teacher, I know that injuries on school playgrounds are not uncommon. It takes something as simple as a student falling down wrong. And accidents happen. We've been fortunate in our school that none of the student injuries that have occurred have resulted in legal action. I do believe the district would support the teacher when an accident happens due to students using equipment unsafely, such was the case in this instance. My school has preventative measures in place for playground issues. We do allow one teacher to supervise 2 classes, similar to what happened in this case. But if there are more than 2 classes, a second adult must be on duty. Teachers are expected to move throughout different zones on the playground while on recess duty, and students have been taught playground safety expectations prior to using any playground equipment. Additional precautions for future incidents could include requiring teachers to see that dangerous behavior is stopped before addressing a separate issue. I do believe that the teacher acted ethically in this case, although the findings were not in her favor. She addressed a dangerous situation, and I believe was right in expecting that to be the end of it. It was not foreseeable, in my opinion, that the student would get injured trying to get off the equipment while it was still moving. The teacher was attempting to provide equally adequate supervision to other students when an issue arose elsewhere on the playground. The next case was Hall versus Jones. Hall was a teenage boy who was injured in a fight that occurred during PE due to a conflict during a basketball game. The teacher, Jones, was at the other end of the gym delivering a message to another teacher when the incident occurred. The background on this story is that two boys became very aggressive during a game of basketball, and a third student came and pushed Jones into the first student involved. And when this happened, the first student pushed Jones into bleachers, which resulted in injury. Hall's mother sued Jones, as well as the other two teachers who were in the gym at the time for negligence, and claiming that they breached their duty to supervise the boys, since all of the teachers were at the other end of the gym and not supervising the basketball game. Jones requested summary judgment, claiming immunity, but ultimately his request for immunity was denied because he failed to file the appeal in a timely manner, and he also failed to provide a statement showing good cause for the courts to accept his request. Hall's mother claimed that by leaving the area, Jones was outside the scope of his employment, which void his rights of immunity, and the case was allowed to proceed. I believe that Jones would have been supported if this were to happen in my school. He didn't technically leave the gym, so he was still present when it happened. And while his eyes were not on the students at the time of the incident, I don't believe it's logical to expect every student to be viewed by a teacher every second of the day. The incident that occurred was not foreseeable, as the case does not mention that there had been any prior warnings due to escalated behavior before the injury. It also states that after a third student pushed Hall into the first student, that the student pushed him into the bleachers, causing the injury. There's no way that Jones could have known a third student would jump in and cause that chain of events. A future precaution could be establishing the procedure to have a student deliver messages when needed, so that teachers don't have to stop supervising students to deliver messages themselves. I do believe that the teacher's actions were ethically sound in this case, but just expecting immunity almost made him seem guilty, even if he wasn't, because he didn't offer a defense of his innocence. So without defending himself, it makes him seem as if he thought he did something wrong, but that he would be protected regardless because of his position. And then the next case I studied was Johnson versus School District of Millard. Robbie Johnson was a first grade student, and he was injured playing London Bridge in music class. In this case, the teacher, Nancy Patton, had taught the first grade class how to play London Bridge that day and had warned them not to be silly, yell, scream, or swing their arms too much. Johnson was the first to go. It was the first time these students had played the game. The two students that caught Johnson in the bridge swung him hard and fast, according to him, and accidentally let go of each other's hands, causing him to fall into a bookshelf and get a cut above his eyebrow. It was undisputed that the teacher was not watching at the time of the incident, but was writing on the blackboard and couldn't hear Johnson yelling at the students to stop because of the noise level in the classroom. She testified that she saw him when he was caught between the students, but didn't see him fall. He did require 50 stitches and suffered temporary blurred vision above that eye and had ongoing headaches after the incident. The teacher was found negligent for failing to supervise at least the beginning of a new game and failing to stop how aggressively the game was being played, and that her negligence was the proximate cause of Johnson's injury. While the teacher's quality of supervision was questionable, I believe that Ultimately, my school would side with the teacher in this case. Future preventative measures could include professional development on effective supervision for students. While I do believe that teachers should have supervised a new activity, and since the students had not yet demonstrated being able to participate in that activity appropriately, writing on the board is well within the duties of the teacher, and it's not something that any other teacher would think twice about doing when there were students in the room. She had explained the game and the expectations, but 2 students did not follow her instructions, which resulted in a student getting hurt. The teacher was present and hadn't left the room, so in my opinion, students were technically not left unsupervised. So I think that her decisions were ethically sound and well within her responsibilities as a teacher. But active supervision may be something that this teacher could have some follow-up with. That's the end of my presentation. Thank you.